I'm sorry.
I'm green on mine, but I don't know where.
I know.
You're in control.
I know. But not really. Let's see. You're on. Right now?
Yes, sir.
All right. You're on. I'm off.
Thank you. There's one matter on the agenda that was unfinished business, which is the part of the recommendation that was originally made by the compensation structure. We deferred that at the October 16th meeting. We did adopt one of the five recommendations. One of those, I believe Judge Katie requested be placed and provided materials about 3 weeks ago. I believe we should be taking, I know this is just an oversight, but I believe we should be taking up old business before we take up any new business. That's my first observation, so I would move that we move that up above any new business. That would be my motion on that issue. So I would move that we take that up first before any other business.
So your substitute motion to the motion to adopt the agenda as is to move item 6 in front of item 4?
Yes, sir, behind public comment.
All right. Do I have a second to the substitute motion?
Second.
All right. Any discussion? All right, let's vote on the substitute motion first. All those in favor of the substitute motion say aye.
Aye.
Any opposition? Substitute motion passes. We'll now revise the agenda with item 6 to move behind public comment. All right. Next item up is public comment. We don't have sign-in sheets, so we're going to let people come up and speak if they wish to speak to any item that is on the agenda, and we'll limit you to 3 minutes. First person up is Mr. Chris Walters from the Governor's Office.
Let's see, are we on? I think we're on. Thank you, Mr. Chairman and members. We appreciate your time and being here and for your diligence and hard work. Christopher Walters, Deputy Executive Counsel to Governor Jeff Landry. We wanted to come down today to provide some brief comments. I apologize, I wanted to stay longer today, but I have another meeting that I have to be in shortly down the hall with a different committee. However, I did want to pass along the Governor's Office request for the board to consider delaying consideration of the old business district chief's compensation structure, as well as the state public defender's district defender compensation plan, and possibly the agenda item regarding consideration of requests by district defenders regarding non-renewal of their contracts. Specifically, 5 of the district defenders chiefs sent the governor's office a letter late Monday afternoon, requesting to meet with us to discuss changes and possibilities and what may happen in the future or decisions that may be made. And we would respectfully like the time to be able to meet with those district defenders and hear those concerns and hear any possible solutions or any ideas that they may have, and so we would just make that request to the board humbly to say, if you so choose and desire, we would like some additional time to be able to consider all of these items and have those discussions before the matter gets fully decided by the board. Thank you all.
Thank you. Okay, normally I would say we would have all public comment before we address the agenda. However, in light of the request from the governor's office, which may make public comment moot if we take items off the agenda, I think we need to address first the request from the governor's office on whether the board has, if there's anyone who wishes to entertain the governor's request by making a motion to table items 4, 6, and 7 until such time as the governor's office has a chance to review and I mean, I don't even mind setting a meeting to take it up, but whatever. Does anybody wish to do anything?
I'll make that motion so we can discuss it.
All right, I got a motion by Judge DeMaye.
Second.
And a second to table items 4, 6, and 7. Now we can discuss it. Any discussion? Hang on, Paul. Turn your mic on.
Oh, yes, Red. Okay. I have a question regarding the length of time it's going to take to go through the process that you're suggesting.
Sorry about that. Thank you. I believe 30 days would be sufficient. And, I would pass along that request with the full understanding and acknowledgement that I know many of our board members are not close by to the Capitol. And so we appreciate, the time and efforts that it takes to get here for these meetings. And so we make that request knowing that it would facilitate another board meeting, but I would think 30 days would be sufficient time, or perhaps less if we can get to it. If the board, if the board needs to meet at a slightly earlier time, I think we could probably get it done within maybe 3 weeks, have those meetings and discussions.
Thank you. A question to the chair. When is our next schedule? Do we have a next scheduled meeting?
We do, but it's in June.
Okay. So
But I mean, I'm not opposed to scheduling a special meeting just to address those items that are tabled if need be.
okay. That's all the question or comments I have.
Judge Dax?
But there we go. If we could talk about these separately, because I think they may have different outcomes. With regard to the two items that deal with the compensation, one is the recommendation that's already been through the committee, and the recommendation came back to the board to be addressed. It's one of 5 amendments, and as I said, Judge Katie attached that one. That's one issue. The compensation plan that Mr. Starnes has attached, I think we've dealt with that before, but to the extent there's anything new in there, I would suggest that we could refer that to the committee and let the committee make a recommendation on that. That would take care of that one. The third one I think is a little trickier, and that's the one for the request by the 5 chiefs. And as I read, and respectfully to each of the board members, but as I read Section 170 of Title 15, once we receive this letter, it says, upon receipt of a request for a hearing, the board shall appoint a 5-member hearing committee made up of 5 board members. The board shall designate the chairman. And the board is then through with that part. It then is turned over to the committee. My understanding is the committee under that statute has a hearing in 30 days. That may well accommodate this 30 days. If they need less than 30 days, the committee would not have heard within that. So I believe we have a statutory duty to appoint the committee and appoint the chair. Whether that committee moves forward within that 30 days would be up to that committee, and they could basically defer to the request to not take any action within that time. So my motion would be, if you want to defer Mr. Starnes' compensation plan that we've heard before back to the committee to let them make a recommendation, that would be what I would make a motion for. The second one, I don't think we can refer it back. It's already come from the committee and had a recommendation. And the third, I think we have a statutory duty to appoint the committee and a chair. And then the committee has 30 days to move. So my motion would, or observation to the other members of the board would be, I think we're bound by the statute to at least do that. I'd defer to any other comments if I'm reading this wrong.
Well, let me just say this. I'll say this from the get-go. The statute refers to a hearing under 170 when there is a termination for cause, a mid-contract termination, not a non-renewal. We are a quasi-public body. As such, this quasi-public body sought an Attorney General opinion. The Attorney General has issued an opinion indicating that a non-renewal of a contract is not entitled to a hearing. There's been some discussion in emails between members about being concerned as to whether or not we would be opening up to liability of any kind if we don't do hearings. The one thing I'm positive of is that members of a quasi-public body such as this board will have zero legal responsibility to anyone for following an opinion of the Attorney General. That's what the Attorney General is for. Now, if there's litigation and a court decides differently, so be it. That happens. But there is zero legal responsibility to a public board member who exercises a vote based upon an opinion from the Attorney General.
But the opinion of the Attorney General is not law.
It's not law.
Right.
No, it's instructive to us.
No, it's advisory.
It's an advisory opinion. In fact, public bodies are encouraged to seek them. But here's the thing. We don't have the authority as a board to hire district defenders. We don't have the authority to decide who gets the job as a district defender. That's clear. The state public defender does under the new law. We don't have the authority to overturn the public defender's decision that he doesn't want to renew a contract. We don't know as individuals what district defenders are doing their job and are not doing their job. And we shouldn't. It's not our job to do that. That's the job of the Office of the State Public Defender. The old law gave this board lots of power. The new law took a lot of that away. I don't believe that their request for a hearing is well-founded and therefore doesn't trigger a 30-day delay. Now, if the governor's office wants to get involved and see what's going on, I understand that. They made requests of the governor's office. It's my understanding from Mr. Walter's statement that it was because of the letters by the 5 district defenders to the governor's office that they're making this request. Since it's them that triggered this, then I would ask whether or not the 5 district defenders would waive the right to any 30-day provision for a hearing, or at least waive the right for it to begin until such time as they meet with the governor's office, and this board sets a meeting to follow that, and then at that point, we could trigger the 30 days if this board votes that they're entitled to a hearing. I'm just giving you my opinion. It would be a way out.
Respectfully. Yes. Okay, great. Thank you.
I'm sorry.
I would, to follow up on your comments, the first concern I have, I do believe 1570 has been triggered, but I will say this. I'm not inclined to support a pausing or a moving of this topic to another date for a couple of reasons. One, and I'll be real frank, I think it's very possible that this board, as it is currently formed and exists, will not exist after session. And the possibility of pushing this can open up the door to there being no further action. I think there are notes, or there has been a request that all of every instance where this oversight board is named, that it is replaced with the state's public defender office, and that request has already been submitted to legislation. Legislation is posed to start fairly soon, in a couple of weeks. Okay, so that's one of my points of hesitation and reason for not wanting to support moving this, due respect to the governor's office. It's just my opinion. Secondly, I think Mr. Chairman mentioned that, this is really specifically an issue as to, based on the AG's opinion, a hearing is only triggered when we're dealing with an issue of termination, not non-renewal for contract. Now, this is the exact reason why I addressed in the email all the other board members, and I specifically referred to Mr. Brett Brunson's letter, who was one of the letters that specifically said that he believed he was terminated, and then secondly was given no reason for termination. Now, if you read that in context with the AG's advisory opinion, which again, I agree with other board members as previously stated, this is not law, this is advisory, then it would be triggered. The AG's opinion it supports that. And then secondly, my concern is not just about illegal exposure. It's not about what the disposition of any potential lawsuit would result in. The fact of the matter is, one, we're going to get named first. That's my concern. I personally have never been named in a suit. So that's a problem for me. Now, I don't have a problem being named if it's a matter of addressing something, righting a wrong, or giving an opportunity for fair hearing or what have you. But my point is that we're not at the point of the disposition. We don't know what the judge or whomever will decide. Anything is possible, and I'm not secure in the notion that because we're a semi-quasi public board, that we would be free and absolved of any liability. So I don't think that's been determined yet. Again, I will reiterate all of my original requests, and my request in the email to add to the agenda was specifically worded in a way that would not allow a motion to strictly based on non-renewal contracts to do away with all of these letters and all of these points of concern. My request was to add to the agenda an element that was worded in a way that covers the non-renewal of contracts matter as well as the issue of employment status. That was going to would accomplish a right to hearing of all the above, or at least a discussion as to whether or not a hearing committee should be formed. That was my only point. It wasn't worded that way on the current agenda, which what we're discussing now. It's limited only to non-renewal contracts. I don't believe that these issues are limited to just that. And I start with Brunson's letter, which was the very first one that was submitted. My final comment onto this is, I will reiterate the fact that the revised statute 15, section 170 does have an inherent 30-day period. And I think it would encompass or be considerate of the time that the governor is asking for. And finally, it's the board's obligation, I believe, at this point to determine whether a hearing should be added. Respect the public's opinion and the governor's request, but I think we have a separate obligation. And I would even suggest and encourage, it would be wonderful if the governor could continue to have a conversation with these chiefs who sent letters to him directly on his separate agenda and time.
Okay.
That's all.
Mr. Chair. I just want to, I agree with several things that you mentioned, but here's my concern. Number one, if we get the letter, the statute says we shall appoint a committee. I can't get past that. Number two, your distinction that this is a non-renewal is you're presupposing that that's a determination that's been made. We've not seen a contract. We don't know if there is a contract. We don't know what it says in that contract, and that is the exact function of that committee. We cannot say we don't owe them this because it's a non-renewal, because they have asserted that it's a termination. And until someone investigates the distinction between those two and what that contract, if it exists, may say, I don't think we can make a decision on that. That's supposition. I go back to the letters say they were terminated. The statute says if we get a letter, we shall appoint the committee. The committee doesn't have to meet for 30 days. It can meet sooner. I think we have a duty under the statute. I respect Mr. Walter's request. I think 30 days gives him plenty of time to meet with these folks. I just don't think we can ignore that. Shall.
My response to both of you is every letter that I received, and I received one from every one of them, I received emails as well as letters by certified mail from all 5 district defenders. and everyone references non-renewal of district defender contract. Their wording.
No, sir, that's a quote from Mr. Starnes' letter.
I'm looking at Mr. Brunson's letter.
Look at the rest of them.
His letter also goes into the
He says he was
specified
constructively
terminated.
terminated.
Yes, and
Well,
that's what
here,
I was-
here's the thing. We are all either former judges or current lawyers. We all know that the contracts are through June 30th of 25.
What contract?
That's-
Where is the
The
contract?
district defenders contracts.
Where is it?
But I don't know that that's true for all of them. In fact, Mr. Brunson's kind
Well, then apparently, before appointing a committee and triggering anything, there needs to be a request. If you all feel you need to see the contracts that are not being renewed,
No, sir, that's what the statute is for.
The-
It's for the committee to view.
no, the statute is for when someone is being terminated for cause.
And they have alleged
That's
that
what
in
he's
their letter.
alleged.
And we are not here to judge that. We don't have any evidence on that. It says, when we receive a letter where they contend that they've been terminated, we.
Oh, it doesn't say when they contend. That's not what the statute
I made
says.
my point. And I would move that that matter not be removed from the agenda.
Okay, we have a substitute motion to not delay item 4. Got a second?
I'll second it.
Got a second from Judge Katie. We'll vote on the substitute motion first, unless, is there any more discussion from board members?
First again, can you define again what item 4 is?
Item 4 is on the agenda, consideration of requests by district defenders regarding non-renewal of their contracts. And simply put, we had a motion on the floor and a second to grant the request of the governor's office to delay items 4,
6 and 7.
4, 6, and 7, not 5. 4, 6, and 7. The substitute motion is to delay only 6 and 7 and not 4?
Yes, sir.
And we have a second to that. And the only reason we're addressing it now is, obviously, if we delay all of them, then I suspect there's some public comment that won't need to take place today, and that's the only reason I took it out of order that way. So the vote first is on the substitute motion, and that is to delay only 6 and 7 and not 4. Everybody clear on that? All right. Let's have a roll call vote. I don't have the roll, but I'm just going to go down the line from Judge Pitcher. On the substitute motion. Ms. Gray? Next?
Not delay.
Not delay? That's, all right, that's 2 yeses on the substitute motion.
Yes.
So you're in favor of the substitute motion not to delay?
Correct.
All right. Peter?
So I would be against. I think I would vote to delay.
So you vote no. Then you'd vote no. Okay. I want to make sure Judge DeMaye understood. You want to not delay the district compensation item, correct? All right, I just want to make sure.
No, sir, it's not the compensation item.
I'm sorry.
I apologize.
The contract renewal, number 4. All right, so we got 3 in favor of the substitute motion, 1 against.
I'm in favor.
In favor? In favor? Judge Thaxton in favor? Ted, in favor. Motion to not delay the item number 4 passes, which means the other items are delayed, and that is items 6 and 7 on the compensation plan. Those items will be addressed at another meeting.
Mr. Chairman, the motion was made, but not, I don't think we voted on it.
That was the vote.
On the main motion.
Oh, no, his motion, I clarified his motion. The substitute motion was to delay 2, in other words, to delay 6 and 7, but not 4. And he said, yes, that was his motion. So we voted to delay 6 and 7, but not 4. All right, now let's return to the agenda and see if there's any public comment relative to items 4 or 5, which are the only 2 left on the agenda. Anybody have public comment?
Mr. Chair, you may have lost me in this process.
Well, that's very possible because a couple of times I lost meat.
Maybe I'm not the sharpest knife in the drawer today, but I'm sorry. Is this better?
You got to turn it on.
Yeah, I'm looking. Here we are there? Are we there now?
Yes.
Thank you. Mr. Chairman, my name is Pam Metzger. I'm formerly a professor of law at Tulane. I've been a member of this bar since 2001. I have served on the former iteration of this board. I'm one of the lawyers that was appointed to represent all of the Orleans Parish inmates after Katrina. I've worked in rural parishes across this state. I've worked in urban areas across this state. And I came today to share some thoughts that about the importance.
Can you tell me which item you're addressing?
No, because you've confused me.
All right.
I'm here to speak to questions related to the request for a hearing.
All right, that would be item 4.
So I'm here today to speak about item 4.
All right, proceed.
Thank you. So what I wanted to bring to this board broadly is, I guess I would say, a big picture view about why independence matters and the conundrum that really confronts this board as it takes this issue on. It is always true that that the catch-22 of public defense is, on the one hand, everyone who is involved in public defense has the great honor and the great duty of standing behind the Constitution of the United States and the state of Louisiana in guaranteeing that there is someone who stands between every single one of us and the awesome and overwhelming power of the state. And when that funding and power comes from the state, there is already an inherent challenge in how you guarantee independence. Independence for a public defender is akin to loyalty, which is the core of any lawyer's values in what they owe their client. Loyalty and confidentiality, you get none without loyalty. In this instance, being free from conflicting loyalties is particularly challenging because in this new universe, after the unwinding of Act 307, this quasi-public board that you have no longer has oversight. You now have a gubernatorial appointee who cannot be removed. Mr. Starnes, I hope it never happens, but Mr. Starnes could be in a coma and could not be removed, except by impeachment, right? The only person who stands between Mr. Starnes and his employment is the governor and your board's vote to approve him. The only person who stands in a meaningful way about appointment is the governor, which means that when Mr. Starnes acts in his oversight responsibility over district defenders, chief defenders, we have to be very careful and thoughtful about making sure not only that he is acting independently, but that there is the clear indicia of independence, right? We want to avoid even the appearance of impropriety. And so I want to highlight some of the concerns that inure in a decision to send a one-line letter without explanation that ends the service. Note, I am not using termination or non-renewal.
Pardon my interruption. You have a minute left.
Thank you. These are the concerns. Unless there is an open determination of what's happened here, new defenders will not know what they need to do to please Mr. Starnes. How can anyone know what's necessary to succeed? And then we have to worry about what the reasons are. And I'm going to lay out three very alarming possibilities and one good one. One good possibility is Mr. Starnes looked at these defenders and said, you know what? They're not doing their jobs. And if they're not doing their jobs, I'm not doing mine. I'm not going to have them continue. But we ought to worry. There are 9 women who are chief defenders in this state. 3 of them are about to lose their positions. That's alarming. We ought to worry that the state public defender serves at the will of the governor, and 5 long-standing defenders with more than 100 years of experience between them are losing their jobs. And lastly, we ought to worry a lot about whether anything those defenders have said to this board is associated with their termination. And I would encourage you to take that obligation seriously, both to exonerate Mr. Starnes of any accusation of wrongdoing, but also to assure every defender and their clients that their constitutional rights are being honored. And I thank you.
Thank you. Good morning.
Good morning, members of, Mr. Chairman, members of this committee. My name is Jean Feria. I am a career state and federal public defender. I was the first public defender hired under the old board for Act 307. And I would just like this board to consider why would you not want to hear people who are the promoters and the protectors of due process in this state? Why would you not want to hear? Because these reasons are important to the success of public defense and the representation of poor people accused of crime in this state. These are 5 defenders whom I know well and whom I support, and I just have to ask you, why would you not want to hear in your capacity with supervision and oversight? I heard what you said, Mr. Chairman. However, I do believe that this statute provides you with a great deal more than you think you have, but the very least of which is to provide to the public, to the defenders themselves, and to the people we serve as public defenders. What is it that you are looking for? What is it that the state public defender is looking for? What is it that the governor is looking for in this role as state public defender? And I think the bottom line is you are the protectors of due process here. And these 5 defenders are entitled to your consideration and due process. Thank you.
Thank you. Anyone else? Public comment? All right, I can stop timing. All right, that'll conclude public comment. Next item on the agenda is number 4, consideration of requests by district defenders regarding non-renewal of their contracts.
Mr. Chair?
Yes? Oh, I'm sorry.
Thank
I
you.
don't remember that I got to touch buttons.
I was
Frank. I'm
trying to be
sorry.
polite and wait for you.
Just remind me, it's okay.
Okay. At this time, I would move that a 5-member hearing committee be appointed to hear the requests for hearing and investigation presented by the 5 district defenders who've notified the board in writing pursuant to 15:170.
Got a second from Judge Cady. Any discussion on the matter concerning this board's duty to, right to, authority to? Paul?
I'm not sure whether we have the right, and there seems to be some discussion as to whether or not the obligation to have a hearing. But I think it would be appropriate to have a hearing, even if we do not have an obligation to do so. It would inspire confidence in this board and in the public defense system.
My question to you and to Judge Thaxton and Judge Cady, who seconded the motion, is, can someone point to me the authority that we would have to overturn the decision of the state public defender if he chooses to non-renew a contract?
Yes, sir.
What is it?
It's in Section 170. The hearing, the only duty we have as a board today is to appoint the committee, and its 5 members, and to appoint its chairman as a board.
And to schedule a hearing.
Once we do that, we're done. The committee itself then is required within 30 days to conduct a hearing on the matter. That's within 30 days of the receipt of the request, so I assume we would have to go by the date of the earliest request.
Well, each one's independent.
Well, that would assume there were 5 different hearings.
It's going to be 5 different hearings. There's 5 different district defenders requesting. If you're going to have a hearing, there's going to be 5 of them.
I would think that's up to the committee, but after that, at a minimum, there's items that are provided for what the committee will consider, and then there's a report after the receipt of that. That report is a determination of whether to accept or not Mr. Starnes' action, to put it in our case, That report is brought to the board. The board then makes the decision whether to accept the recommendation of the committee. So yes, there is statutory authority for overturning what Mr. Starnes has purportedly done. And I would reiterate, the board, the committee is the one that will determine whether there are contracts, what those contracts say, whether there's been a termination or a non-renewal. And I think that goes to the heart of what they've requested. So yes, in response to your question, there is authority.
Press a button, Peter.
Which button? The one on the right?
I guess, yeah.
Okay.
There you go.
So I have a question for Judge Thaxton. So it's my understanding that what you're saying only applies if 170 is triggered, and you're saying that 170 applies in this case, but you're not explaining, at least to me, specifically why 15:170 is triggered. Because we have, I mean, we have this Attorney General opinion, you know, that's well reasoned, and it states the right to a hearing and an investigation under 15:170 is limited to instances to which a district public defender is disciplined or has his contract terminated early. There is no right to a hearing or an investigation if the annual contract is simply not renewed. I understand your position that 170 applies under the facts before us, but can you tell me why does it apply? Specifically, what in the statute instructs you that it does apply? Because I'm not seeing it, and I'd like to be educated by you or anyone.
I will say again what I believe triggers this. The letters from the chiefs, which are what we consider in whether or not to grant a hearing, say they were either constructively terminated or terminated. For you or any of us to decide that that is true or false or under the contract it is appropriate, we don't have that evidence, and that's not our job to consider and make that determination. Our job is when we get the letter, if it says terminated, we grant the hearing at the committee, and the committee decides what to do with
Why
that.
not
You're going straight to the
this?
committee and the evidence.
But if we don't have that evidence, if we don't have the contract, if we don't have the information, how can we vote intelligently without postponing this and receiving this information?
Because the statute says when you receive the letter, you shall appoint the committee,
Where
and
in
it's
the
5
statute
members.
does it say that?
It says right here.
Read it.
I mean, this is the third time I've pointed it out. I mean, it says upon
Section C.
Section D, 1. Upon receipt of a request for a hearing, the board shall appoint a 5-member hearing committee made up of 5 board members. Number 2, the board shall designate the chairman, who shall function as the presiding officer. There is no provision for taking or considering evidence. It says, upon receipt of a request. We have a request. The request says they were terminated or constructively terminated. That is the end of our inquiry, in my opinion. And that's my motion. We need to appoint this committee, let the committee do its job. If they affirm the action, they bring that recommendation back. If they don't, they bring that recommendation back. That is about as clear as you can get in a statute.
And I would like to add, can you hear me?
I'm going to get to you.
Oh, perfect. That, for one, I initially only pointed to Mr. Brunson's letter, but there's also, I'm holding the letter from Chief Defender Deidre Fuller, as well as Chief Defender Tricia Ward, and they also specifically alleged that they were terminated. So for any further question, it's not just one, right? And I'm not saying that that's the last list, as I forgot my copy of the letters, but termination, we have that. It's triggered. It triggers D under 15-170. And then if you go on, just commenting to an earlier question as to how this whole process goes on, the statute further provides exactly what needs to go on in the hearing. Okay, and so the first thing is, and I thought the only thing that we needed to consider was whether or not a hearing, the right to have a hearing has been triggered. Again, I submit that it has by the statute. But just for information purposes, the statute goes on to give us an idea of exactly what the power is, everything from what type of evidence should be considered, testimony, the process after the evidence has been received. I mean, it goes on the second part of the statute. So in general, I would just say that we have, this is in response to the question of what power do we have as the board. Well, the board, in the term of a hearing committee, has some very detailed power, and the statute lays it out very clearly, I think.
Mr. Chair, I'd call the question.
Hang on, I have a comment. As of right now, all 5 district defenders are still employed. No one has been terminated. And y'all are assuming because they allege that they've been terminated, that they have been. They're all still serving in their capacities until the end of their contract on June 30th.
How do you know there's a contract?
I would submit, Mr. Chairman, that there is an issue as to at least one one chief who does not have a contract that's even in existence. And secondly, to your point to your question, these letters that have come out from the state public defender, they specifically say that there's a non-renewal. Okay, that's fine. So it's not even whether you can be fired and say it's effective next week. But this is essentially what we're looking at, potentially, as they personally believe they're being terminated as effective, June or whatever the letters that have come from the state public defender's office indicate. So to me, that is the same. It's if you believe you're being terminated and you've been given, even if it's a future effective date, it's still the same.
Well, I think, look, this is for what it's worth. I think before we have an obligation to appoint a committee, we, as a board, have to determine whether or not termination is involved.
I disagree respectively.
I call the question again, Mr. Chair.
That's not for us to decide. I believe that's for evidence to be considered by the hearing committee.
Look, I want to give any and everybody on this board an opportunity to be heard on this because this is important. And if somebody on this board wishes to speak, I'll hear them.
So I have another.
Judge DeMaia had raised his hand. Press your button so I can know what your number is. How you not lighting up? There you go. Now you are.
Okay, good. All right. It seems that what we're doing is certain allegations have been made, and we're saying, well, those allegations aren't correct, so we're denying a hearing. I think the purpose of a hearing is to find out what actually happened. And we're going based on basically reading a petition and an answer and saying, okay, we're going to decide the case. I think we need to find out, what actually happened, and we do that with a hearing instead of just going on what each side alleges. And that's my comment.
All right, thank you, Peter.
So
I got you. You're on.
I'm on. So I'm also looking at 170C, which is, the way I'm reading this is a bit broad and somewhat vague. But it says a district public defender who feels that he has been terminated without just cause. And it says, as defined, I have to look at that definition, may demand in writing a hearing and an investigation. And upon receipt of the request, the board shall appoint a 5-member hearing. I'm asking members of the board, does anybody have any comments or feel they have an analysis with regard to this, to see where it says a district defender who feels he has been terminated actually can trigger a hearing?
Anybody have any comments? You will be now. Yes, sir. You are now.
Right, and as I read it, I'm inclined to believe that a hearing and the committee has been triggered. And consequently, once the committee completes its work, that report comes to the main board, and the board can in turn refer that finding to the governor's office. I mean, if since
It comes back to this, it comes here. It doesn't go to the governor's office.
Mr. Chairman, I understand that. Mr. Chairman, I think that this committee can send something to the governor.
Oh, absolutely.
Okay, and because we are the supervisors of Mr. Starnes, and consequently, Mr. Starnes worked directly for the governor. So this would be our ability to, in turn, let the governor know whether or not Mr. Starnes has actually given these 5 people their due process rights and so forth.
Anybody else have a comment?
Which button do I? I would just say that I concur with both the comments made by my classmate, Judge DeMahi, and Judge Pitcher. I do think that what the 5 defenders alleged triggers the provisions in the statute, and I think we should go ahead and set the committee and have the investigation and get a finding and then move from there.
All right. Everybody done with comment? All right. I have a motion and a second to appoint a hearing committee. Before we vote on it, I believe, I understand it's for the committee to decide, but I believe there needs to be 5 separate hearings because rationale for what was done on each individual could be completely different, and I don't think that one hearing applies to all. I just...
Are you suggesting one committee?
One committee has 5 separate hearings. I don't know. I'm not appointing 5 committees. There's not enough of us. But I think there has to be, if it's going to happen, there has to be a separate hearing. And I believe the very first thing they need to do is determine, A, is there a contract? And assuming there is it being terminated or is it not being renewed? Because those are terms of art legally. I think.
Chairman, with all due respect, I think we should appoint the committee and let the committee decide the issues, right? And so.
Well, I agree with that, but I think,
whether or not there should be 5 different hearings. I think the committee, once they are established, they can determine whether or not they need 5 different hearings or whether one would suffice.
I think the board has to give some direction to the committee, since we ultimately are going to be making the decision.
Not what the statute says.
I disagree, but.
All right. Let me start with, it's a committee of 5?
Yes, sir.
Well, that's more than half of this board. Let me start down at this end. Judge Pitcher, do you wish to serve on the committee?
Excuse me. I think we need to vote first on the motion.
Oh, I'm sorry. I thought it was voted on. On the motion to appoint a committee, all in favor say aye. Aye. All opposed say nay. Ayes have it. Now, Judge Pitcher, do you wish to serve on the committee?
I will serve.
Ma'am, do you wish to serve on the committee?
That would be Judge Gray.
Judge Gray, I'm sorry, Gray. I was trying to remember, I could remember your first name, and I didn't want to call you by your first name.
Oh, okay.
Ernestine.
It's okay. Ernestine, it's fine. Yes.
All right. Judge DeMaye?
I will serve.
Peter?
Sure, I would serve.
That's 4. Judge Katie?
No, I cannot. I don't. I'm on one committee already.
I understand. That's why I'm making it voluntary. Dre?
Yes, I will serve.
Ms. Boutte, that makes 5 committee members. Now, it says we're to appoint a chairperson to the committee. Those are the fun jobs, trust me.
Does that have to come from the committee?
I don't think so. It's in the statute. It comes from the board.
I'd recommend Judge Pitcher.
The board the statute says the board chooses a chairman.
I nominate Judge Pitcher.
I second that.
Judge Pitcher, your face tells me you're not happy with that. Do you accept the nomination as chairperson of this committee?
Well, you read my face right. I prefer to not serve against the chairman. I have some other obligations that kind of check my availability.
Peter, would you serve?
Well, I prefer to defer, as I do have some other
Judge DeMaye?
serious obligations.
I don't think there's anybody left.
Well,
I'll do it.
all right, is everybody in agreement with Judge DeMaye serving as chairperson?
Yes, sir.
All right. All right, I'll leave it to the committee to do whatever. However, I still believe that they need to make some decisions up front.
I would like to call a committee meeting immediately following this meeting, being chairman of this meeting, to discuss logistics.
Understand? All right, that leaves the item 5 on the agenda, which is the capital defense contracts review, subparts A through E. How do you wish to proceed on that, Mr. Starnes? I'll have to get y'all a new chairman. I'm done.
Thank you, Mr. Chairman and members of the committee. My name is Ramey Starnes. I am the State Public Defender. The role of the board in terms of contract approvals is triggered when the contracts are over $250,000. These are often the capital contracts. We are in preparation of those capital contracts, and we'll have something for the board to approve in that regard. I believe the meeting is in June. The items on the agenda were at the request of Mr. Hernandez, so we provided materials to the board via Dropbox. The materials we provided are all the materials that we have in regards to the capital defense contracts, the areas of inquiry. So that is my briefing, and I will address any questions.
Mr. Hernandez.
Mr. Chairman, I got a Sears and Roebuck catalog dropped in the Dropbox.
As we did all.
And I haven't had time to look at all the items in there, but I wanted them for this meeting. I didn't think we'd get to them in terms of going through them. I thought everybody needed an opportunity to look at it at their leisure and see what's in those contracts. I'm not going to sit here and preach today like I did the first time I talked at this meeting, but I'm going to say I want you to please look carefully at each contract and at what the state is paying for with each one of these nonprofits. And if you in good conscience think that we're getting our money's worth, then vote your conscience. But I want you to look at that. That's all I'm asking. And with that, I'd move to defer any action on the capital contracts until we've had to the next meeting, the June meeting even.
It's June 18th.
Yeah.
Right now, that's what it's scheduled for.
I would second it.
All right, we've got a motion and a second to table item 5, subparts A through E, to the June 18th meeting after a review of the documents provided by the Public Defender's Office. Any opposition? Then it passes. Other items have been delayed at the governor's request. Our next scheduled meeting date is June 18th, unless anything done by the governor would necessitate something prior to June. Let me ask Mr. Storns if there's anything that comes out of the governor's review of the district defender's compensation plan. Do you need it addressed prior to June?
No, sir.
Okay, then it can be handled at the June 18th meeting, it sounds like. Now, having said that, assuming we have this committee to hold hearings on the 5 requests within the next 30 days, which brings us to April the 20th, does the statute indicate any timeline for us to take action? I didn't see any.
Not until after the committee reports to the board.
All right. I'll leave it up to the committee to determine when they report to the board, but let me just say this. If I were a district defender with a contract that was under review, and if in fact that contract is terminating on June 30th, the sooner I know whether or not I have a contract, the better. So if after the committee conducts whatever it conducts and makes a recommendation to this board, if we have to have a meeting to address that, I understand that, and will do my best to make myself available to handle action, just so that people whose livelihood is being affected will know as soon as possible, which is why I understand the letters went out when they went out.
We appreciate that, Mr. Chairman.
I mean, I'm in favor of giving people as much notice as possible if they're not going to have a job. No doubt. All right. Anybody have anything else to address other than for me to remind the committee, hang tight, y'all going to discuss scheduling? All right. In that case, I'll entertain a motion to adjourn.
So moved.
Got a motion and a second to adjourn. Any opposition? Hearing none, we're adjourned.